Welcome to Ivy and Ivy, Generations of Justice.
Welcome back to Ivy and Ivy, Generations of Justice with attorneys Sam and Vic Ivy of Ivy and Ivy Law. I'm your host, Evan Mack. With deep roots in West Tennessee and decades of courtroom experience, Sam and Vic represent injured individuals in serious personal injury cases and help clients navigate complex liability issues with clarity and strategy. In today's episode, we're breaking down comparative fault in Tennessee, what happens when more than one person may share responsibility for an accident, and how that impacts whether someone can recover compensation. Gentlemen, welcome.
Morning. Good morning.
Good morning. So, Stan, let me start with you. In a typical car accident case, how does the issue of shared fault usually arise?
Yes, sir. So in an auto accident case, like any other personal injury case, you have to have three things to be successful. And the first of those is liability, followed by damages and a pocket. But liability is the first inquiry that we look at. And as you mentioned, in Tennessee, we follow a system of modified comparative fault. And if the plaintiff shares some responsibility in the accident, if the jury were to find that, then their recovery would be reduced by that portion of fault that the jury found them to be responsible for. So if the plaintiff is less than 50% at fault, they can recover for their injuries. But the way that comes up many times is, for instance, I'm thinking of a situation where there's perhaps a traffic intersection and both parties claim that they had the green light, or they're alleging that the other party ran a red light. That's going to be an issue that has to be investigated. And we try to attack that early on, investigate that. Of course, you can't change the facts, but you can ascertain every piece of information and obtain it that you can find that would establish the facts for your client. So that's what we do early on, is collect every piece of evidence that we can to determine who was at fault in the accident before proceeding forward in the case.
And Vic, can you explain how Tennessee's 50% rule works, and what it means for someone who may have contributed to that crash?
Sure. Tennessee actually evolved from a thing called contributory negligence. And that was long ago. Contributory negligence was if you were at 1% at fault in an accident, you could not recover because you were somewhat at fault. Just even a little bit at fault, you could get no recovery in Tennessee under the contributory negligence rules. There was a case called McIntyre v. Ballantyne that came around, several years ago. It's probably been around for roughly 30 years now, where the Tennessee Supreme Court changed the law to mean that comparative fault could apply. And comparative fault is just if you are less than 50% liable for an accident, then you can recover. A plaintiff may be 49% at fault and the defendant 51% at fault. The plaintiff can still recover that 2% in there. If the plaintiff is more than 50% at fault or 50% at fault or more, then there can be no recovery for the plaintiff. So it's actually a very good rule that the Tennessee Supreme Court came about and finding, and then was later codified or in the Tennessee Code Annotated applied. So Tennessee has evolved from the old English law of contributory negligence up to the modern rule of comparative fault. Now, there's some states that joined Tennessee that still have contributory negligence as their law, and there are different ways to get around that. So if an individual is listening to us and they're in another state, adjoining state to Tennessee, and they're at fault or have an accident, they should give us a call so that we can discuss the case with them and actually apply that other state's rule. But in Tennessee, comparative fault is the rule of the day.
So, Sam, when you're evaluating a new case, what kinds of facts make you concerned that fault could become a major dispute?
Yes, sir. So as I mentioned, differing testimony about perhaps who had a red or green light at an intersection, conflicting facts from each of the parties involved with no witnesses is problematic. But we do various things such as pulling the airbag control module off these vehicles now to look at contributing factors as well that may have backed up our client's story to investigate the case, such as speed. Speed is a big factor of comparative fault in various auto accidents. You know, if you have someone that is pulled out in front of somebody else, but the other driver was going 100 miles an hour or 120 miles an hour, that's obviously going to be taken into consideration by anyone that looks at this, and ultimately the jury, if you get that far. But we're always looking at what is the potential of getting to a jury, and what will the jury think of these facts. That's what we're always talking about, negotiating around, and ultimately deciding if we can pursue the case to win it for our client or not. That's because we want to win. So that's what we're looking at, is what's the likelihood that we can prevail for our client and recover compensation for their injuries. So if you have a question about an auto accident, if you were in one, give us a call and we can walk through that together for free.
So Vic, how do these insurance companies usually, use this comparative fault to reduce what they have to pay people?
Well, that's an interesting question, because the insurance companies collect premiums after premium, and we all pay the large premiums for our insurance coverage. And then they want to fight you for the recovery that you try to get against the at-fault party, which sometimes can be your own uninsured motorist coverage. And they'll fight you even over collecting from your own insurance company. So let's just say that you had for an example, if you were rear-ended driving down the highway, and the insurance company may say something like, you slowed down too fast, you actually contributed to the accident occurring, rather than normally we would think if somebody, is rear-ended or hit in the rear end of a vehicle, usually the at-fault party will be the one that actually did hit the car. But they can actually say that you're comparatively at fault, even if you are hit in that sort of situation. So they're going to use that to try to lessen the amount that you're paid out, even though you may have horrific injuries of some sort. Then they're still going to try to reduce that amount by saying you are comparatively at fault. That's just kind of an underhanded tactic that's sometimes used by the insurance company. So comparative fault can be a good thing, can be a bad thing. Folks need to give us a call so we can discuss it with them and show them how it works. And we use that all the time in front of juries when we're trying these cases.
So Sam, what type of evidence tend to matter most when determining percentages or fault? Is it the crash reports, the witnesses? Is that black box data? Is it expert testimony? Is it all the above?
I would say all of the above. So first, when we meet with a client, of course, their side of the story, their testimony is going to be very important, coupled with the crash report. That's going to be the first pieces of evidence that we have. Even though the crash report is not per se admissible in Tennessee, it can still be used to refresh the police officer's recollection on the stand. So those two pieces of information are very important. And then we'll get further into the case. If more investigation is needed, we will pull the black box data off of things such as 18-wheelers have a ton of information on those. If there's a liability dispute in a big trucking case, we will most definitely probably get an accident reconstructionist, an engineer, someone of that caliber involved. And then, as you mentioned, the expert testimony comes into play in evaluating these cases as well. And we have individuals that we retain on cases where liability is in dispute to offer an opinion about what they think was the cause of the crash based on a number of different studies and factors that they've gotten from the black box, tire marks, the way a particular impact of a vehicle may have occurred, to determine a lot of things that engineers are well versed in. That we're your lawyers, we can argue for you, but we have to rely on the expert testimony at times to prove the case as well. So all of those things are very important in analyzing liability. And you can't do it on your own. You need to talk to us so we can get involved and start looking at this early on to get you the most money out of this case that you may have.
If someone admits something, Vic, if they admit at the scene that they might have been partly responsible, does that automatically damage their case?
Well, it very well could damage the case if they go ahead and admit fault. If they just state that they may be partially at fault, something may have occurred, a deer ran out in front of the vehicle, a dog, something like that. If there was a sudden emergency or something that occurred that could cause them to make a statement like that they were partially at fault. However, it's best not to make a statement at all at the scene because you may have bystanders that misinterpret what is said. An individual may say, I may have been at fault, and it be interpreted by a bystander or witness that they were totally at fault, and then that could come out at trial and really damage your case. So you need to contact Sam or myself. Let us discuss that. There are ways that we can keep those statements out of court. Sometimes at trial, a well-timed objection is very important. Sometimes jurors don't understand about objections and what's admissible and inadmissible at trial. And between the two of us, we have over 50 years of combined trial experience. Sam and I have been in almost every courtroom in West Tennessee, including all the federal courtrooms. And so we know how to try these cases and how to get the correct evidence in front of the jury and to keep out some of the evidence that we need to as far as the admissibility is concerned. So just because you make that statement that I could be partially at fault at the scene may or may not hurt the case. I know that's kind of a lawyer's answer to it, but we sometimes can keep that statement out of court.
With that experience, though, Sam, between the two of you, can you share an example of a situation where fault was, hotly contested and how that affected the negotiations or strategies or how you guys handle it?
In a scenario I brought up earlier in the episode, we had a fact pattern where someone was coming down a highway, 2-lane, or actually 4-lane highway. The other party had turned left and come through the median and pulled out in front of them. And a bad wreck obviously ensued. But the speed of the person that was traveling down the highway was argued about, and we had a lot of discussion about that as a contributing factor in the wreck. Now, with that being said, at the end of the day, we ended up being successful in that case, but that was taken into consideration from a comparative fault standpoint. And so, if someone out there has a case where they think they may have shared some fault in the wreck, I would still urge you to contact us and let us look at that situation and determine, is there an avenue of recovery here? Because every car wreck is different. Every personal injury case is different. So give us a call and let us talk to you. The initial consultation is free, and there's no fee unless we win for you. So there's no risk in not, and giving us a call to let us look at the case for you.
Good stuff. So, Vic, how does comparative fault affect settlement discussions differently than it affects a case that goes all the way to trial?
Well, the insurance companies know which lawyers will go to trial and which lawyers are just trying to get a quick and easy settlement in the case. So these insurance companies know that Sam and I will go to trial, and it makes a huge difference in trying to settle the case because basically we're always thinking about what is a jury going to do? How will a jury look at this case? So if a person is somewhat at fault or has some comparative fault in the case, we can evaluate that and see how our client is going to appear in front of a jury. We've tried many cases, so you can sort of take a look at their temperament, see how they're going to appear, how they're going to testify in front of a jury, and evaluate all that. Now, a lot of lawyers that you see on TV or whatnot are just a pretty face, and they just want to get a quick and easy settlement. But the insurance companies know which lawyers are going to go to trial, and Sam and I definitely will go to trial to get every penny that an individual deserves. So we take a look at each one of these cases, evaluate the case, whether or not our client has some fault to share in it or not, and then we present that to the insurance companies, and they will fight you. The insurance companies fight for every penny that they can keep, but we want to get every penny that our client deserves as well.
And to close things out there, Sam, for someone who believes were partially at fault, what should they understand about whether they still may have a valid claim in the state of Tennessee?
So the interesting thing is ultimately it would be up to the jury to apportion that percentage of fault. And you never know what 12 individuals in the jury box are going to do with a particular fact pattern or what they might award, or 8 in federal court. You only get 8 jurors in federal court. But, it's hard to have a crystal ball and say what the jury would do. Now, we can use our experience to kind of evaluate what we think the jury might do with this particular situation. And that's what we'll be discussing with, the insurance adjuster and or opposing counsel to try to put a value on this claim to see if it can be settled prior to going to trial. But if, as Dad said, if we need to go to trial, we're certainly capable and comfortable with doing that. So every single case is different. And we know our clients by name. Every case we analyze this thoroughly to determine what course of action we need to take to make to get the best result for our clients in each case. So
good stuff. Gentlemen, thank you so much for your time.
Thank you, sir.
Thank you for listening to Ivy and Ivy, Generations of Justice. If questions about fault are complicating your injury case, Sam and Vic Ivy can help you understand your rights and protect your future. Visit ivyandivy.com to speak with Sam or Vic today, and be sure to like, subscribe, and leave a review so more Tennesseans can get the guidance they need after a serious accident. And we'll see you next time.
Thanks for watching. Be sure to hit that like and subscribe button and leave us a review in the comments.